is just trying to.
It's-
I think we'll still have to.
Hmm?
I think Crea's just trying to get online.
Yeah, we have,
I'm here, thank you.
okay, 1, 2, 3, 4, 5, 6, we're good.
Yep.
Okay, just about.
Yeah.
Okay, welcome, everybody. Before we get started on this hearing board, I'd like to do a land acknowledgement. We'd like to acknowledge that many Indigenous nations have long-standing relationships, both historic and modern, with the territories upon which we are located. Today, this area is home to many Indigenous peoples from across Turtle Island. We acknowledge that our watershed forms a part of the treaty and traditional territory of the southeastern Anishinaabe. It is on these ancestral and treaty lands that we live and work. To honor this legacy, we commit to being stewards of the natural environment and undertake to have a relationship of respect with our treaty partners. So I'm going to call to order, resolve that the agenda for the hearing board of the Board of Directors be adopted. Okay, Tracy and Jerry, all in favor? Carried. Okay, I'm gonna do a roll call. Jerry Byrne,
Present.
Mark Doble, Peter Franzen,
Present.
Kriya Pettengill,
Present,
Lloyd Rang, not, Tracy Richardson, Robert Rock, Harold Wright,
Present.
Jeff Forbes, and myself, present. Thank you. Okay. So, are there any declarations of pecuniary interest? None seen. Okay, motion to sit as a hearing board. Resolve that the Board of Directors sit as a hearing board for the purposes of hearing an appeal of a stop order. May I have a mover and seconder? Jerry and Peter, all in favor? Carried, thank you. Okay, approval of the minutes. Hearing appeal of a stop order, June 25th, 2026. Resolve that the hearing meeting minutes of June 25th, 2026 for the appeal of a stop order be adopted as circulated. Okay, Mark and Jerry, all in favor? Carried, thank you. Okay, we are now going to conduct a hearing under section 30.4 of the Conservation Authorities Act with regards to the appeal of a stop order involving activities engaged in for the properties identified by ARN number 1651 001008 13000 and 1651 001 008 12900 in Omemee, City of Kawartha Lakes, Ontario. A request for the appeal is provided in the agenda. This is the continuation of the hearing held on June 25th, 2026, which was adjourned to allow for review of new information presented by the appellant prior to the meeting. Kawartha Conservation has adopted a regulation under Section 28 of the Conservation Authorities Act, which allows Kawartha Conservation to issue stop orders for activities which contravene Section 28, 28.1.2, and regulation made under Section 28.5 of the Act, and where activity has caused or is likely to cause significant damage affecting or likely to affect the control of flooding, erosion, dynamic beaches, or unstable soil or bedrock, or in the event of a natural hazard, the damage will or is likely to create conditions, or circumstances that might jeopardize the health and safety of persons or result in damage or destruction of property, and the order will prevent or reduce the damage or potential damage. Staff have reviewed this proposed work and prepared a staff report, a copy of which has been given to the person who was served the stop order and the board. The hearing applicant was invited to file material in response to the staff report, a copy of which has also been provided to the board, and a response to the report from staff also provided. The Conservation Authorities Act indicates that a person who is served with an order under this section may request a hearing before the authority within 30 days after the service of the order. A written request for a hearing that includes a statement of the reasons for requesting the hearing. And after holding a hearing, the authority shall A, confirm the order, B, amend the order, or C, remove the order with or without conditions. In holding this hearing, the Kawartha Conservation Hearing Board is to determine whether or not to confirm, amend, or remove the stop order with or without conditions. In doing so, we can only consider the evidence as presented to us. The proceedings will be conducted according to the Statutory Powers Procedure Act under Section 5 of the Canada Evidence Act. A witness may refuse to answer any question on the ground that the answer may tend to incriminate the person or may tend to establish his or her liability to a civil proceeding at the instance of the Crown or of any person. The procedure in general will be informal, without the evidence before it being given under oath or affirmation. The rules of evidence before the board are informal. If the person who is served with the order and/or agent has any questions to ask the board of directors, she is free to do so, providing all questions are directed to the chair of the board. The hearing will proceed as follows. Number one, staff and/or council of Kawartha Conservation will present an overview of the stop order and the reasons why the stop order has been made. The person who is served with an order will then have the opportunity to ask questions of staff based on their presentation. Following this, the members of the board may ask the staff questions. Next will be the presentation by the person who is served an order and/or agent, followed by questions by Kawartha Conservation staff and/or council, and then questions by members of the board of directors. Lastly, the board of directors will deliberate and make a decision on the stop order. A resolution advising of the board of directors' decision and the particulars of the decision will then be adopted. Introduction of hearing participants. Kawartha Conservation. Christy McCabe, Director, Planning and Development Services. Rusty Rustenberg, Compliance Officer and Permitting. Tanner Lang, Water Quality Specialist, Certified Wetland Evaluator. Council Ken Jewell, Gardner Roberts. Okay, so an appellant, Andy Murdoch, or also agents if he has them. Okay, so we're on to number 8, presentations by staff or council. Presentation by staff. Go ahead, Christy.
Thank you, Madam Chair, and through you. As you know, we're here for the continuation of the appeal for the stop work order. Council for Staff has prepared a notice of motion as well as a factum for the board, and I would like to turn it over now to Mr. Jewell to present that to the board.
Okay.
Thank you. Thank you, Madam Chair. And Ms. McCabe, I'm picking up a little bit of an echo. I don't know if you're hearing it.
It's an iPhone, some iPhone is causing a problem.
Oh, that's Korea.
That's probably Korea.
Kriya?
There.
Here we go.
Muted it.
Okay, go ahead, Ken.
Right, that's better, I think.
No, it's not.
Not
No,
really.
okay.
Is it you?
I don't have mine on. Mine's off.
I'm just wondering if it's picking that through the computer.
On a system.
I don't have, mine's not a 16.
Let's try that.
Let me try it again,
No, it's still an echo.
because I just turned mine off.
Does anybody have their computer?
We never run into this problem.
No.
No,
So Kriya, do you have both your audio and video off?
yes, she does.
Okay. Hmm. Well, I guess we'll have to just mug through.
I'm wondering, would it help if I were to sign back in? Maybe that might help.
Or maybe just take off video, I don't know, maybe.
It's more an audio thing. It sounds like it's looping the audio through two machines, so.
Yeah, maybe.
Yeah,
If we mute our mics, will it mute the speakers?
Yes.
Okay.
Why don't we try logging off and logging back
Yeah.
in, Ken?
That's a good
Right, let's
idea.
try that.
Try that.
You are muted, Ken.
Maybe he's trying to just.
Yeah.
It happens with me on a phone call once in a while, right? There's an echo.
Is it working here?
Who's the iPhone 16?
That's great.
That's Korea.
Well,
It's not the.
it's not her?
No, everybody's muted now, so I think it's something on Ken's. end.
On his-
He's speaking and it's looping his voice back through and feeding it back into the microphone.
Okay.
If he had, sometimes if he has earbuds or headphones set, it might be something
Yeah.
that's sort of. Is your microphone off, this one?
No, it's on. If I turn it off,
I
then.
think that'll work well. I think it may have been at my end that there was a double session, because I don't hear the echo now.
Correct. Yeah, I think you're good to go, Ken.
Okay, so let me just start. Thank you for the introduction. My name's Kenneth Joel from Gardner Roberts. Max Ray Ellis, who's a summer student with Gardner Roberts, is observing. And I just want to start with a threshold legal issue. And if I could ask Melanie to share the screen and refer to a document that we received. It's part of your hearing, excuse me, documents, and it's a letter from counsel for Mr. Murdoch. If you could share the screen with that would be great. Yes, thank you. And I'm really directing this both to you, Madam Chair, but to Mr. Murdoch. So we received a letter from Heather Richardson, counsel for Mr. Murdoch, requesting this hearing. And we have communicated with Ms. Richardson on a number of occasions by way of email. And we in fact served our materials on Ms. Richardson, and regrettably, we did not receive a response. And what I'd like to deal with as a threshold matter is whether or not Mr. Murdoch is continuing to be represented by Ms. Richardson, or whether or not they're no longer, as we say, on the record. So perhaps Mr. Murdoch could help us with understanding whether or not Ms. Richardson is still his lawyer, because I understand that she's not here today.
He is not representing.
She's not. Okay.
Okay, so I just didn't quite hear that. I heard she's not
He's not.
present.
She is not representing him.
Representing
Okay,
Mr.
so
Murdoch.
she is no longer your counsel in these proceedings.
That is correct.
Okay, thank you very much. So that helps. Okay, so then the second thing, we can take that letter down. The second thing I'd like to refer to is the notice of motion that I've filed. And I'm going to try to be as informal as I can, and not be too formal, but I am seeking an order, a preliminary order from the board before we get going with the hearing, which really just sets the parameters for the hearing. And the reason that I'm doing that is that this stop work order procedure is relatively new. The Conservation Authorities Act was amended to include it. And to my knowledge, the proceeding that you're about to hear with respect to a hearing concerning the stop work order is the first time in Ontario that any board has dealt with this. So I think it because it's new and it's new procedure, I think it's important to set the parameters about what this hearing's for and what the hearing's not for. And so just by way of that, by what I'm going to be seeking from you, and I'll explain why, is two orders. And they've set them out in, if we could just scroll down to paragraph A. Oh, and by the way, and I should say, let me just say at the outset, and I think this is important. I'm here as counsel for staff. I am not here as counsel to the board. I've played that role in other circumstances, but I'm not doing that here today. I'm not counsel to the board. I'm counsel for staff. And part of the reason that we did that was because it was in reaction to the lawyer's letter that was sent. So the first order that I'm seeking is an order that this hearing today is just dealing with the narrow issue of whether or not the stop work order should continue in place. We are not here, and I'll explain why, to decide whether or not Mr. Murdoch should get a permit. There is no permit application before you. And I want to be just very clear that that's what we're here to do. That's number one. The second thing that I'm going to be seeking a ruling on is that the approximate regulation mapping, which is passed pursuant to the statute and the regulation, is admissible in evidence as proof of the legal existence of the wetland on site. So those are the two items that I'm seeking a ruling on. Now, in order to support that, I'd like to refer you to the factum that I filed, and you all will have it on, as I understand, you have tablets that you can look at as we go through this. And again, I'm going to try to be relatively informal in this process. And But what I am going to do is just follow along the written argument, but I'll try to summarize it as concisely as I can. And so if we start with, if we could just scroll down to the introduction and overview. As Madam Chair set out, this hearing concerns the roll number set out. And just by way of a little bit of chronology to help you understand this, in March, Rusty Rustenberg, who's here today and available for questioning, received an anonymous report that work was underway within the wetland. He then visited the property on March 26th, and he witnessed an excavator, and I'll show you a picture of that in a moment, working within the regulated feature. And he also noted a tile drainage machine, which at the time was not in the regulated feature. And this is part of the material that's been filed, but I've also put in my factum. You'll see, if we can just scroll down to the figure, you'll see this was a picture that Rusty took of the backhoe doing significant work on that day. Just by way of quick background, Mr. Rustenberg spoke to Brian Fairfield, the contractor on site, and he then issued a verbal stop work order on that day. 2 days later, Mr. Fairfield contacted Mr. Officer Rustenberg and provided the name of the landowner, Andrew Murdoch. Then subsequently on April 2nd, Mr. Rustenberg met with Mr. Murdoch and Mr. Fairfield to discuss this. And at that time, it was brought to the attention of the Kawartha Regional Conservation Authority that the drainage machinery had been moved into the regulated feature and had subsequently broken down. And if we could just scroll down to the next picture, you'll see this is a picture of what we say is the drainage machinery. And you'll hear evidence on this. So I'm not here to give evidence. So I'm just here to set out the parameters of what the legal parameters. I'm not giving evidence. You'll hear this from Ms. McCabe and Mr. Rustenberg if you'd like to hear from him. So it was following that, Mr. Murdoch and Mr. Fairfield were told not to do any more work. And then subsequently in April, Mr. Murdoch attended at the office, and it was at that time he provided the letter which has triggered the request for this hearing. Now, as a general point, I just want to say, and this is important as a general overview, that our position and the position of staff, and if we could scroll down to paragraph 13, I'll just take you there. I just want to be very clear what our position is. Our position is that the illegal work in this case has destroyed the best evidence of the existence of a wetland. And the report that was later provided by Mr. Murdoch from Colville Consulting, we say is of limited or no value. Because A, as I understand it, there's no one from Colville to testify about it. But B, even if there was, it is analyzing the site after the damage was done, not at a time when the wetland was alive and thriving. And it's for that reason that we need to go to the evidence in the approximate regulation mapping to understand what the wetland looked like before the damage was done to it. And so if we scroll down in my argument, the ARL mapping established, and we've got pictures of it. We'll show you pictures later. Ms. McCabe will talk about it. But we're going to be introducing evidence of approximate regulation mapping in 2014 by the Ministry of Natural Resources, and you'll hear Ms. McCabe speak about that. And we say that clearly shows that a wetland existed as far back as 2014. It was affirmed in 2026, and we're going to provide evidence of that. So in terms of the legal framework here, just if we can scroll down, you can, thank you. Just as an overview, Section 28 of the Act prohibits work in a wetland unless there is permission. And wetland is defined in, if we could just scroll down, wetlands defined in Regulation 4124. And I won't read it out. It's there for you to consider. Ms. McCabe's going to take you through it in terms of what its definition is. And the regulation provides that one can put in a permit application. However, unfortunately, in this case, Mr. Murdoch did not do that and did not seek permission before allowing the work to be done. And so therefore, what we say is, we could go to paragraph 21, it's the purposes of today is to determine whether or not any further work should be allowed to be done, but we ought not to be engaging in any discussions about the scope of the wetland, because the wetland in effect has already been destroyed. So it's a bit like somebody saying, it's like somebody shooting a person and then saying, well, the person is no longer alive, therefore you can't charge me with murder. Well, that's because you destroyed the body, and then we say you destroyed the wetland. And it's very important in the way the Conservation Authorities Act is structured, as said it in the case of Provenzano, and I won't take you through it, but it just, it was a case that I was counsel in, where the Ontario Land Tribunal affirmed that the whole idea of the Conservation Authorities Act is an ex ante scheme where you apply before you do any work for permission, not afterwards. Okay, so then what are we doing here today? The stop work order can be issued under 30.4 of the Act. And Ms. McCabe is going to take you through the test. I'm not going to take you through it, aside from saying that the sections set out in Section 24 of the Factum, in essence, I just will say this. You have to decide today whether or not the activity that has been done is or has caused significant damage that will likely affect the control of flooding, or if we could just scroll down to paragraph 24, please. Or, and it's a disjunctive test, or the damage would likely jeopardize health and safety. So it's either or. If you find that it will affect control of flooding, or if you find that it might jeopardize health and safety of persons, then if you find that, then the only other question is, would the stop work order prevent or reduce the damage? And we say that it will and ought to be upheld. Okay, so the key here is, in terms of the parameters of what we're doing today, is, as I say, we're not here to decide whether or not Mr. Murdoch should get a permit, because there is no permit application before you. And on top of that, and if we could just scroll down to paragraph 42, thank you. I've set out in paragraph 42 under section 28.1, the wording is, and if we just scroll down one more page, please. Thank you. You'll see I put in an excerpt from section 28.1. The authority can issue a permit if, in the opinion of the authority, the activity is not likely. And the key is it's proactive. In other words, somebody comes to the board, or somebody comes to the Conservation Authority, says, I'd like to do this. and they provide plans about what they'd like to do. And then the board will decide and can decide whether or not that would be in the future likely to cause any damage. It doesn't say has not likely or hasn't. And so what that means is, in my respectful view, the new act certainly makes it clear you can't grant what's commonly called a stale dated permit for work that's already been done. So that's the essence of the law in this area. And so I'm just going to ask if we could just flip back for a moment to the notice of motion. I'm sorry, there's one more thing I should have done. I'm sorry, if I just bear with me for one more thing before we go back to the notice of motion.
Sorry, Ken, which?
The factum, the factum.
Yeah, so I'm still on the factum. I'm just going to, I just wanted to go back to one small item in the factum before I go back to the notice of motion and seek a ruling. And just bear with me for one moment. Yeah, if we could just go back, I just skipped over it. I'm sorry, I'm trying to be quick. If we could just go back very briefly to paragraph 33. So this is with respect to regulated mapping, and I just want to walk you through this because this is the second order that I'm seeking. Regulated mapping is governed by Section 4 of Regulation 4124, and that states an authority shall develop maps depicting the areas within the authority's area of jurisdiction where development activities are prohibited under paragraph 2 of subsection 28(1) of the Act, which shall be filed at the head office of the authority and made available to the public on the authority's website and by other means that the authority considers advisable. And the whole idea, as you know, members of the board, of mapping is it makes it easier for a person in the community before they buy a property or before they do any work to come in to the authority and ask, in essence, is my property regulated? And they can come in and they can look at this mapping, the approximate regulated mapping, and they can determine whether or not if it's within the yellow lines of that mapping, and they can determine whether or not their property is in fact regulated and whether or not they need to make a permit application. So it's a good system that allows people to, in a transparent way, determine whether they're regulated. And I won't take you to the law unless you want me to, but there's a decision called Halton Region Conservation Authority and Ahmad, where the court ruled that the approximate regulation limit mapping was admissible in evidence under Section 25 of the Ontario Evidence Act, and that's precedent. The property here, as Ms. McCabe will take you to, is within the ARO mapping, and we say contains a significant wetland. So that's the authority. I won't take you to the law unless you really want me to, that supports the order that I'm going to seek. So if we could just go back to the notice of motion. And thank you. And so what I'm asking you for, and I want to give clearly Mr. Murdoch an opportunity to respond or to this before I seek a ruling from you. I'm asking for an order that today's proceedings be strictly limited to the issue of the stop work order under 30.4, and B, that the approximate regulated mapping, which is in your hearing materials and which Ms. McCabe will take you to, is admissible under Section 25 of the Act as proof of the existence of the wetland that's on site. So those are the two preliminary matters that I'm asking I believe by doing this, it will make the proceedings more streamlined and more efficient. And so I'm going to turn it over to Mr. Murdoch to respond to those two, subject to any rulings or questions you have, Madam Chair. I would turn it over to Mr. Murdoch to respond.
Thank you. Okay. Andy, Mr. Murdoch, yep,
First of all, there's a few points in your brief that need some adjustment. The first being the fact that you suggested there was a tiling machine on the property and did damage to the property. There was never a tiling machine on the property, ever. It was a brushing machine. It was not a tiling machine. Secondly, when you talk about destroying a wetland, the M&R did the mapping. The mapping was unregulated. When I bought the property in 2005, and if I go back, sir, to February the 8th, 1823, Crown granted the land for farming. For 200 years, that land has been farmed. For 200 years, there's never been a flood. And for 200 years, there's never been bedrock on the property because the bedrock ends north of Downeyville. So there's no issues that way. It's more like Sandy Loam, it's more like Downeyville, Holy Land. Anyway, there's that point. The ground has not been disturbed. Vegetation on top of the ground does not constitute a change in the actual landscape of the land. I changed the land in 2012 when I pushed up some topsoil. The wet spots on the land that exist today are because I pushed up topsoil, and now I want to rectify it and put it back. So that I created the wetland. When you landscape your own property, you can do what you like. And I have the right to farm, and I have the right to move my dirt around on my own property without bringing any in or taking any out. As for section 28, there's no bylaws in the city of Kawartha Lakes for brushing or cutting trees. That's number one. There's also no bylaws for moving dirt on your own property, which I've already stated. The mapping when I purchased the property in 2005 requirement did not have any regulations or any requirements other than agricultural zoning and M1 industrial zoning. M1 industrial zoning, as most people realize, could contain a wetland or wetter areas that can be filled. I have no intention of doing that because it's not necessary. It's to be farmed. But there was no mapping at the time of purchase, which you referred to. There's several other points here, but that gets into what I'm going to do with the property. The point is that a lot of the things that you've brought forward, and you can bring your experts, there's no standing water. It does not meet the 4 criteria. It also states under the 4 criteria that a farmer can farm a wet area for agricultural use and to improve the land. If I wanted a permit to tile it, then I would apply for a permit. But in the essence of things, I don't really need a permit from the Conservation Authority to tile it because there is no wetland. The wetland you're talking about doesn't exist. My consultant did an excellent job, whether you like it or not, of presenting a non-biased report that went into the fact that there was 2 or 3 wet holes and there was one spot that could be considered significant because it's a natural grassed waterway that flows from east to west along the rail line and then into the rail ditches. There's a mention of the proximity in some of the briefs about the river. The river has no impact on this property whatsoever. The rail line was put through in the early 1900s. It was raised, it's deep ditched. It has a cement culvert that runs through. So the water on the south side runs north and through the culvert into a marsh that I don't own and then into the river. And as I said, there's never been any flooding, there is no bedrock, it doesn't meet any of the 4 criteria that are listed under the proper regulations. I have an indication from Kawartha Lakes in reference that Kawartha Lakes is unique. Yes, they are. Because from what I've seen, it goes over and above the provincial guidelines. That's it.
Okay, so, Christy, do you want to present
I think,
at this?
council for staff was looking for a ruling with regards to the notice of motion.
Okay, so we could do that first, okay.
Ken, did you want to jump in?
No, I think that's, I don't have any, just by way of reply, before you make your ruling, I would only make, the only comment I would make with respect to Mr. Murdoch's submissions is, if if there's no one here from Colville Consulting to talk about the report, I will take the position when we get into the evidence that it ought not to be considered. We put it, for the truth of its contents, we put the document in simply because we received it, but it is hearsay and it's an expert report, and you can't accept a document without qualifying an expert. If the expert's not here, he's not qualified to present the report, and he's not available for cross-examination. And I know the rules are more relaxed at administrative hearings, but for key documents, you can't throw in an expert's report without an expert being here. So I would just make the comment that when the time comes, my position is that that report ought not to be accepted for any of the truth of its contents. But with the exception of that, that's all I have to say. And I would then ask for a ruling with respect to the 2 heads of relief that I've asked for in the notice of motion.
Okay, thank you. And so before, yes,
Just procedurally, I've been hearing talks, people using the word precedent setting. So I'm just trying to understand, is there a lower court to this particular tribunal? Or is there was reference to Halton versus Ahmed as being precedent setting? Is that a higher level?
that would be to the lawyer. I would not be.
Yeah, no,
Yeah.
I question through you,
Sure.
Madam Chair.
Yeah,
To Mr. Joel.
So if I could address that, thank you for the question. It is a decision of a provincial court. In that case was a prosecution brought by Conservation Halton. And in that context, it acts as precedent for the proposition that approximate regulation limits mapping do go in. Now, that's precedent. You know, I'm asking you to follow that precedent, but the board has to make its own ultimate decision as to whether you know it ought to. I certainly would say that to my understanding, it's a leading case, but you know the board has to consider it as it is. When you say higher court, it's an interesting phraseology because it is a provincial court. It's not a superior court. It's a provincial court in the context of regulatory offense proceedings, but it certainly is a court presided over by a justice of the peace in that case. I hope that helps.
Yeah.
I'm just trying to understand this a little bit better. My understanding of precedent is that a precedent is set by a higher level than the existing. So if what you're saying, the decision in Halton was a higher level than this, if we're at the same level, if we're at the same level, then it's not precedent setting. It's instructive, and could be, and I understand that, but it wouldn't legally be a precedent.
Well, I mean, I think maybe it might help in order for me to answer that question, if I could ask Melanie to put the case up on the screen. It's at tab 6 of the Book of Authorities in relation to the factum. I think that might help to clarify this. So it's the tab 6 of the Book of Authorities in relation to the factum. What's on the screen, what's on the screen is just the reference to the section.
Okay, sorry, which section?
So it's tab 6 of the Book of Authorities in relation to the factum. I think you're in, I think you're in the different Book of Authorities. This is the procedural Book of Authorities, yes.
That's the
Yeah,
one.
that's not the right book. It's the other Book of Authorities.
That one there, yeah.
Yeah, so we could go to tab 6, tab 6 of that. Sorry, it's tab 6. If you go to the index, you can click on it on the tabs. And if necessary, I can share my screen if it'll help.
Just give us 1 sec, Ken. She has to change the view on the screen so that
Oh,
she can
okay.
find the index.
Yeah.
Yeah.
They don't like that.
I don't know how to get back to.
Really, I think my question is simple enough.
That too.
The other way to do it, if I could make a suggestion, is it's at PDF 242. If you could scroll down to 242.
There we go.
That's it. Okay. So let me just, in order to answer your question, I understand your question, but I think it's important to look at the case because it concerns me that you might say you could disregard this. I mean, look, this is a Ontario judgment of the Ontario Court of Justice, and it is a legal decision that's been reported. It's reported in you'll see 2017 ONCJ 552. So it's what we call a reported decision of the court. I happen to be counsel in that case, and argument was put forward about the force of the approximate regulation mapping, and it was thoroughly discussed by the judge, and the act was cited with respect to the reference in the act because the act refers to this mapping, and this is very important. The court then referred to the Ontario Evidence Act as referring to official copies that are in or pursuant to statutes or regulations. And if we could just go to paragraph 26 of the decision, it's the highlighted portion right there. The judge in this case said, I accept the submission of the prosecutor that the approximate regulation limit map made in accordance with the provisions of, at that time, Ontario Regulation 16206 is admissible in evidence in these proceedings as part of the regulation under Section 25 of the Ontario Evidence Act. And the court continued to talk about the keeping of the aerial maps and why they were there and what their purposes were. And so therefore, the map was held to be admissible. So what I would say in response to your question is, if, I would say this is binding to the extent that it's a reasoned decision
Just the
pursuant to the act and a court. Now, if this board wants to depart from this, then I would say I think you'd have to give good reason why you're not following this precedent. So it's not, whether it's binding on you or not, I think it is, in the sense that it's a court as opposed to an administrative tribunal. So to that extent, it's higher in that sense. It's a court. But the other point is the reasoning is sound. And so if this board is to consider rejecting it, then you would have to, in my respectful submission, give good reason why this logic shouldn't apply.
Are you fine with that?
Yeah, I mean, really, all I needed to know was that this was from a court rather than,
Yeah.
we are basically a quasi judicial tribunal.
Yes,
And at this level, people that, or other tribunals that are at the same level as us they may make decisions that are very useful and instructive, but they're not precedent setting. Because the case referenced by Mr. Jill is at a court. A court is higher than a tribunal, so yes, it is precedent setting. That's all I needed to know.
yeah. So I have a question also, Mr. Jewell. So what was precedent setting was the allowance of the mapping. Is that specific? Is that correct?
Yeah, so not only is it saying the mapping's admissible, but what it's saying is that it is admissible for what's called the truth of its contents. If you look at paragraph 32, it says it's admissible for the truth of its contents. And so what that means is that once the mapping goes in, if the mapping shows that there's a wetland, then that is proof of the fact that a wetland exists on this property. And so that's what we're saying in this case, in the Murdoch case. We're saying that, and Ms. McCabe will take you to it, but what we're saying, and I'm seeking a ruling from you, is that given that there is approximate regulation mapping that shows the wetland on this property, that is admissible as evidence that there is a wetland
Okay.
on this
Yep,
property.
I get it. Yep. Thank you. Okay. Oh, hey, Jerry.
Through the chair to the lawyer, part of it scares me, this idea that we're doing something totally different for the first time anywhere. And I don't know the ramifications of that, and I don't know what it used to be, and I don't know what the new thing is. Regardless of that, has mapping ever been challenged and proven to be an error? In my lifetime, with my limited exposure to things like this, I've found a lot of old mapping and the techniques used and the motivation behind it was very generic and not really defined down to the level that some people interpret it as. So it's a tribunal thing goes, has mapping ever been challenged and proven to be an error?
So that's a great question. And let me just talk a little bit about how the act is structured. So the way the act is structured is that prima facie the mapping shows that it's a wetland. Okay, that goes in as evidence it's a wetland. Now, if under the act a person, to your point, says, well, the mapping's outdated and wants to challenge it, there's a way to do that. And how you do it is you put in a permit application and you take the position, if you want to do it, you can take the position that you think the mapping is outdated or erroneous or that the lines have changed. Okay. And if you do that and you call expert evidence from an expert, there is a provision in the regulation, and I can take you to it, that says if the mapping is inconsistent with actual evidence that shows the mapping's incorrect, then the wording of the statute takes precedence. So in other words, if the mapping, let's just say, for example, the mapping is updated. If you can hire a consultant and the consultant comes in and says, I don't believe this mapping is accurate, and here's the evidence why I don't think it's accurate, then under the act, and I do want to take you to the section that says this, then under the act, the board then actually has the authority in that circumstance, the board has the authority to say, okay, we've heard expert evidence, and that expert evidence prevails. In effect, it prevails over the mapping, and so that's an important section to keep in mind. So maybe if I could take you to, Melanie, if you could go to the Book of Authorities that we're still in, if I could take you to tab 2, or I'll give you the number. If you could go to 142, PDF 142. Sorry, just the Book of Authorities, not the exhibits, but the Book of Authorities. At PDF 142, I'd like to refer to the wording and the regulation, because members asked a very important question and I want to address it.
Sorry, Ken, is that the Book of Authorities in relation to the factum?
Yes, the Book of Authorities in relation to the factum, and it's at PDF 142.
Maps of regulated areas.
Yes, we could just display that.
Yeah. It's up on the screen for the board.
I'm not seeing it. I'm seeing agenda items.
It says maps of regulated areas.
Just one moment. We're just gonna update what page is being shared, Ken.
Yeah, thank you. This is a very important question that's being asked. Thank you. This is your regulation, the generic regulation that governs all the conservation authorities. And it talks about the authority developing maps, which are required. And the section that I want to take you to is 4 sub 5. 4 sub 5. So 4 sub 5 says this: for greater certainty, in case of a conflict regarding the boundaries of the areas where development activities are prohibited, under paragraph 2 of subsection 28.1, the description of those areas in that paragraph and in section 2 of this regulation prevail over the depiction of the areas in the maps. So what that means is, and it's a very important question that's been asked, what that means is the map goes in as evidence, and it goes in as evidence. But if a proponent calls expert evidence that convinces the board that in fact that mapping is no longer accurate, and you're right, mapping can be out of date. If they call expert evidence to that effect, then the board has the jurisdiction under this section to say, we're going to use the wording of the regulation itself, and we're not going to use the map because the wording of, or this expert evidence has shown us that in fact that mapping's outdated. So it can be done, and can be done under this section, but it requires a permit application, or it requires the calling of expert evidence from an expert who can say with a degree of certainty that that mapping is no longer accurate. So it's a great question, and I hope I've answered it.
Jerry.
To the chair, actually, I was just looking for a yes or no answer to say, Has it ever been challenged and has it ever been proven to be an error? That's what I was actually after.
So,
And
yeah,
to
and in
that-
answer to that, sorry, look, I'm a part-time professor and I slide into lecturing and I apologize for that. But you know, the answer is I'm not aware of any exact case where that has occurred, but I suspect there is, and I just don't know of it. So I would be hesitant to say, no, because you're asking me in all of Ontario or in any conservation authority, has that ever happened? I could not say, you know, with any degree of certainty that that's never happened. So that's why I answered with more prolix answer to say, well, here's a procedure. Certainly I would say in this case, there's no expert evidence, but I can't tell you beyond any doubt that that hasn't happened before or that it has. Sorry about that.
Okay,
Through the chair, on that note, the mapping, whatever it is, done by whoever it is, that's considered admissible. I'm having trouble wrapping my head around. I kind of get the concept where you say the defendant's consultant isn't here, so therefore it's not valid or not admissible. But I have some issue with that. If there is some actual factual data that's being presented that might be accurate, I just don't know how you throw it out just because he's not present. Yet the person that did the mapping's not here today, and that's admissible.
Well, again, I'm happy to address that, but it's really a simple issue of, and there's cases that I can take you to. Expert, in order, there's a procedure for qualification of experts, and you have to follow that procedure. And that procedure requires that the expert, first off, be qualified as an expert. And if there's nobody here, you can't qualify there's nobody to qualify. So in the absence of that, you can't accept the report as having any value. It's really that
Andy?
simple.
Madam Chair, on that comment, then how do you accept the mapping as being correct? And furthermore, the mapping that was done by the M&R, you have stated it's wetland, significant wetland in your brief, when in fact, the report that I have from the M&R is that it's unevaluated.
Okay, well, let me address that. So I think in order to best answer this, it might help if Melanie, if we could go to the hearing brief itself, and if we could go to the hearing background document, which is Exhibit 7D, Exhibit 3. So I'm referring to our hearing documentation package. Yes, that's it. And if you just scroll down, I'd like to just show the mapping itself. Yeah, so let's just stop right there. So that what you see on the screen is a map that shows the regulated area. This was taken in 2014. This mapping is pursuant to the statute, and as the Ahmad case says, this mapping is admissible pursuant to the statute. It is evidence. It's evidence of what it shows pursuant to the statute and pursuant to Ahmad. And if we scroll down to the next map, we see in 2026, the same regulated area, although this one's slightly different, shows a slightly reduced area of wetland because the new regulations changed the setback from 120 meters to 30 meters. So you have a smaller area of wetland that's shown in the pink. Again, the Ahmad case says this is admissible as evidence of the wetland, and it stands as prima facie evidence pursuant to the Ahmad case. And that's the ruling that I'm seeking from you, that this mapping goes in as evidence of the wetland. Now, Mr. Murdoch wants to call and have an expert here who's qualified to disagree with this. He's free to do so, but he hasn't done that, and there is nobody here. And so my point is, I'm seeking simply a ruling that prima facie, this mapping goes in for the fact that there's a wetland, there's case law that says it, and it's pursuant to the statute and the regulation. And that's why the regulation refers to mapping, for this very reason. It goes in as evidence of a regulated feature.
Okay, thank you. Okay, Jerry?
Through the chair to staff. Was there the option at some point in the past, and I don't know, at some point, if the defendant had came forward and asked for a permit, this would have been allowed?
Through you, Madam Chair. So had the applicant come to Kawartha Conservation in advance of doing any of the work, we could have at that point in time gone out and determined the exact boundaries of the wetland. Unfortunately, it's almost impossible to do so now because the proof of the wetland has been removed.
To some degree, but the elevation and the slope of the land and everything else is still the same. He hasn't disrupted that per se.
True, but there are 4 tests in the act that we need to meet, and one of them is the vegetation that exists on the property to determine whether or not it is a wetland, and that vegetation is gone. And the way that it is evaluated is it must meet all 4. It can't just meet a majority of the 4, 2 of the 4, 3 of the 4. It must meet all 4 criteria in order to be established as a wetland. And so, and even in Mr. Murdoch's report from his expert, it says all the vegetation has been recently removed, so I can't evaluate that, but I can evaluate it based on this other stuff. And so without having the ability to do all 4 tests, that's the point. That's why we have put the stop order in, is so that we can get to the point of evaluating all 4 aspects. But had an application come in prior to, we would have been able to determine that and then give Mr. Murdoch the permit to do what he needed to do, you know, with respect to the unregulated areas. That answer your question?
Somewhat.
Harold, do you have a question?
Well, we touched on it a bit through these discussions here, but basically, to Madam Chair, for clarification, or how are these maps produced? We've seen some examples there in the presentation.
Good question.
These maps, I'm understanding, are produced from a desk with a computer, and probably no one would ever visited this site and delineated this wetland from the other lands on the property. Is that correct?
So through you, Madam Chair, yes, the regulated mapping that we produce, that the board approves each year, and we review it each year and update it. And so in 2014, the map that we showed earlier, that is a layer that is provided by the Ministry of Natural Resources. And they provide us a number of different layers. One of them is for evaluated wetlands and one is for unevaluated wetlands. And the difference of those is exactly that. An unevaluated wetland means that nobody's actually gone out and put it through a rigorous test. It's been done mostly from remote sensing, so aerial photography, satellite imagery, to determine whether or not the wetland, whether or not they think it's a wetland. They establish the boundary of that wetland at that point in time. If it's an evaluated wetland, then it's usually put through a very standardized, rigorous test, including people going out onto the property and evaluating it from that perspective. With the number of wetlands that we have in the province, it's just impossible for them to do it for all wetlands. So in this case, the property is an unevaluated wetland. The boundary hasn't changed. The boundary of the wetland has not changed from 2014 to the 2026 regulated mapping. What has changed is the buffer around it, as was indicated by council. It's because the regulation changed from 120 meter buffer to a 30 meter buffer. But I think what's important to note is that the unevaluated wetland, all wetlands, the presence of any wetland could be established prior to going in and doing any works if we had been approached at that time.
Very good. Very good. Thank you.
Okay, Gary?
think that and taking that into consideration too, but that it's, I think that is probably more so why I think it would be beneficial to see the other report. We're like a take on that property too.
What other report?
The Colville report.
Oh, the Colville, yes, okay, yeah. Okay, Jerry?
Through the chair to staff, the statements that the defendant made earlier about the 2005 purchase timeframe, are they accurate?
I don't have any proof. I don't have any evidence of that. Nothing has been provided to us with regards to that.
I have a question. I know the province did LiDAR everywhere pretty much in our area. Was this area LiDAR'd, if that's a verb?
Through you, Madam Chair, that's not my area of expertise.
Okay.
I'm not aware of that. What I can tell you is that the mapping that the board has approved was done from a remote sensing using aerial photos and
Probably LiDAR.
satellite
Yeah.
imagery to determine what they think is the approximate boundary of the wetland feature. And they provide that as such.
Okay,
And so that makes up the basis of our regulated mapping that the board,
and we get that from the MNR.
we get that layer from the MNR, correct?
Yeah. Okay, Jerry?
Through the chair, just one other question. So was the defendant told and expressed the idea that the report that he paid for wouldn't be valid if there wasn't somebody here to verify it? Is that something that was made aware? Just curious.
I did not, no, I would have just assumed that if he was presenting a report, that he would have somebody to speak to the report.
Okay. So in front of you, is a motion. I'm gonna read it. Resolved that the motion presented by council for staff related to the hearing be adopted, specific to the following. That the collateral attack doctrine precludes the applicant from asking the hearing board to consider at this stage whether or not a permit might be granted, and that the hearing is strictly limited to the appeal of a stop order pursuant to the Conservation Authorities Act, section 30.46. That the approximate regulation limit, ARL map governing the site at roll numbers 165100, 1008, 13000, and 1651001008, 12900, lot 8, concession 4, former geographic township of Emily and Omemee, Kawartha Lakes, Ontario, is admissible in evidence under section 25 of the Ontario Evidence Act as proof of the legal existence of a wetland on site, that such further and other relief as to this board may seem just. So that's the motion. And if somebody wants to move it. Tracy? And seconder, Peter? Okay, does anybody want to speak to this? Okay, Kriya's up there. Kriya, do you have any questions?
No, thanks.
Okay. So you have the motion in front of you. What would you like to do, folks? I'm going to call the question. Those in favor? Okay, Kriya doesn't have her hand up, I don't believe. So that fails. Okay, so we're gonna do a presentation by hearing applicant agent.
Staff? Okay.
Yeah, that's what it says.
Thank you.
Yeah.
Thank you. So through you, Madam Chair, I wanted to take an opportunity to walk you through the process with regards to the stop order that was issued and why we feel that the stop order was justified, which is what is being appealed today. So what we're not appealing is whether or not a wetland exists on the property, what the boundaries of that wetland are, but strictly were we justified in issuing a stop order and should it stand? Okay. And so to do that, I'd like to direct you to page 5 of the staff report, Exhibit 3, which we have seen briefly. Yep, that's the right one, page 5. So going back to that regulated mapping. So Kawartha Conservation is responsible for regulating hazardous lands as well as watercourses and wetlands. And so as part of our annual process, we develop regulation mapping for the board to approve that indicates these are the areas that fall within the jurisdiction of the Conservation Authority to consider and issue permits. As part of those regulated areas, we take into consideration a number of different layers that are provided to us, whether it's from the M&R, in some cases it's staff going out and verifying the presence or absence of a hazard land feature. In this case, we have the approximate value of an unevaluated wetland, and I have explained the concept between an unevaluated wetland and an evaluated wetland. So this is a wetland that was identified by the Ministry of Natural Resources in 2014 as existing on the property, and this is the approximate boundary of the wetland itself. And then if we were to go to page 3, you'll see that this is the regulated area. So this is what the public would see if they were to go to our website and look at what areas the Conservation Authority regulates. And in 2014, that encompasses that wetland boundary that I just showed you, as well as the 120-meter buffer around that boundary, all fall within the regulated areas of Kawartha Conservation. So in 2026, as we do every year, we update our regulated mapping. So the staff go through and pull any of the latest information with regards to any updates to layers from the Ministry of Natural Resources. If there's been any reports from staff with regards to the presence or absence of a feature, and we update those, we bring that report to the board and present it to you and say, this is the new regulated area that we are proposing for 2026. So in 2026, if you go to page 6 of the report, in 2026, this was the wetland boundary that was approved as making up the regulated feature. Okay, so as you can tell, it hasn't changed significantly from the 2014 mapping. The province has not indicated that there's any update to that layer. If you go to page 4, you will see the the regulated area has changed significantly. And again, as previously mentioned, that is because of the change of the buffer around that wetland feature going from 120 meters to 30 meters. So when you look at this property, obviously the area outlined in yellow is the property owned by Mr. Murdoch and where the activity took place. So on March 24th, we received an anonymous tip from a member of the public who said that there was work actively taking place in a regulated area. And so on the 26th, Officer Rustenberg went out, attended the site, and when he got there, he witnessed a backhoe in the regulated area, according to our mapping, that was actively working in the regulated area, removing and stockpiling brush and moving soil. He also noted, and apologies to Mr. Murdoch, what he noted was a piece of machinery that was located outside of the regulated area. It did say drainage on the side of the machine, and so the assumption was that it was a tile drainage or some sort of drainage machine. Apparently it is not, and so my apologies to Mr. Murdoch on that. It was located outside of the regulated area at that time. So we weren't as concerned with that, but we were concerned with the work that was taking place inside the regulated area. So at that time, Officer Rustenberg approached the contractor that was on site and asked him to cease working, right? He said, please stop all the work that you're doing until such time as we can get in touch with the landowner. He indicated that he was not the landowner, but that he would provide the landowner's name and contact information after the fact. So 2 days later, the contractor, Mr. Fairfield, did reach out and provide us with Mr. Murdoch's contact information. And on the 2nd of April, both Mr. Fairfield and Mr. Murdoch attended the office here to speak with Rusty, to Officer Rustenberg, to ensure that they understood the parameters of the stop order and to make sure that that they had an opportunity to speak to what was happening on the property. So at that time, Officer Rustenberg indicated to Mr. Murdoch that all machinery needed to be out of the regulated area and that no work was to continue until such time. Obviously, Mr. Murdoch disagreed with the boundary of the wetland. And we said, well, we'll have to go out and verify that. But until we can go out and verify that, we ask that you stop working, because the longer the work goes on, the potential for more damage happens. At that time, they also informed us that the machine with the drainage piece, the chipping machine that was on site but not in the regulated area, had subsequently, between the 26th and the 2nd, had been moved into and had been working in the regulated area after the stop order had been issued, and that it had subsequently broken down. And so Mr. Murdoch requested that we give him a little bit of time to get that piece of machinery serviced so that he could get it out of the regulated area. Which we did, because dragging it out was probably going to create more of a problem than letting it sit there and get serviced on site. On April 24th, so at that point in time, Mr. Murdoch agreed that no further work was going to take place on the property, and that we would work towards identifying what the boundary may or may not be, and hopefully enter into a voluntary remediation agreement in order to rectify whatever damage was done to the wetland feature, regardless of what the size of it or where it was located. On the 24th of April, Mr. Murdoch attended our office and provided correspondence from his lawyer, which council provided and showed you, indicating that he was requesting an appeal of the stop order on the basis that he vehemently disagreed with the wetland boundary and said that, he disagreed with the fact that there was wetland on the property. I think the letter quotes, vehemently disagrees with the updated mapping, which has recently categorized this as wetland. So we do have mapping that indicates since 2014, so at least for the last 12 years, it has been mapped as wetland, so it hasn't been recently changed or recently regulated from that regard. On June 9th, Mr. Rustenberg attended the site with Mr. Murdoch's consultant to enter onto the property to do the evaluation of that wetland. We have received a copy of that report on the 25th of June. We received a copy of that report. We subsequently had a peer review of that document done. On the first page of his report, which is here, I don't know if you want to pull it up, if you have it there.
I've read it.
Yeah, so on the first page, under the vegetation and site conditions, so I should sort of pause for a moment and just say that under the Conservation Authorities Act, they provide us with a definition of how we identify what a wetland is. And so as I previously indicated, there's 4 tests that we must meet in order to qualify a property as a wetland. And those are that it has to be seasonally or permanently covered by shallow water or has a water table that's close to the surface. That's the first test. The second test is that it must also directly contribute to the hydrological function of a watershed through a connection with a surface water course. That's the second test. The third test is that it has hydric soils, the formation of which have been caused by or the presence of abundant water. And lastly, that has vegetation dominated by hydrophytic plants or water tolerant plants of dominance. So it also does say that it does not include property, so a wetland does not include property or land that is periodically soaked or wet land used for agriculture. Because we know that sometimes agricultural land gets wet during spring freshet. That's not what we're talking about when we talk about standing water close to the surface. So in order to evaluate a wetland, whether or not a wetland exists, you must go through all 4 of those tests. In the report from Mr. Murdoch's consultant, he says in the first page, an assessment of vegetation and site conditions on the subject lands was completed on June 9th. Vegetation over much of the property was recently disturbed or removed, and therefore this description is primarily based on site conditions visible at the time of assessment, so as of June 9th, which means I don't have an assessment of what the property looked like prior to the disturbance. And that is our concern with this property, is the disturbance has been created, and I can't evaluate exactly where the wetland boundary may or may not be, in the words of his own consultant.
Christie,
So, yeah,
in that, he did say there were wetland areas within,
correct.
yes, just to be.
Yes,
clear.
yes, he did identify that there was at least one area, like that there were wet areas within the property and one area that he felt should, warranted a second look. But yes, he did indicate that there was wetland on the property. So the stop work order, when you look at section 30.4 of the Conservation Authorities Act. Sorry, I don't know if you can pull that up for me.
You want to just read it, or is just
I can.
salient point?
I can.
Just the salient point.
Absolutely. So under section 30.4 of the Conservation Authorities Act, when it comes to a stop order, issuing a stop order, it says that an officer appointed under section 30.1 may make an order requiring a person to stop engaging or to not engage in an activity if the officer has reasonable grounds to believe that. And then the piece that is important here is that the activity has caused, is causing, or is likely to cause significant damage. And point 1, that the damage affects or is likely to affect the control of flooding, erosion, dynamic beaches, or unstable soil or bedrock. Or in the event of a natural hazard, the damage will or is likely to create conditions or circumstances which might jeopardize the health and safety of persons or result in the damage or destruction of property, and that the order will prevent or reduce the damage described in clause B, meaning the activity that's taking place. So in this case, our staff identified that there was a regulated area, that there was work being done in the regulated area according to our mapping that did not have a permit, that it was causing or was likely to cause damage to the wetland. And as we know, wetlands act as a control feature, a natural area for water to go during a storm event, and helps to control flooding. And so in that way, we feel that we have met the test of why we would issue a stop order, so that we can determine exactly what the extent of the wetland is, what is the extent of the restoration that needs to have happen, so that we can then move forward from there. So with respect, we are asking that stop order be upheld until such time as vegetation can reestablish, so that a true evaluation of the wetland can take place, so that that restoration can actually happen.
Okay. Jerry, did you have your hand up? Yep.
Through the chair, so that increase, I think, was from 30 meters to 120 meters for the buffer.
Reduction.
Reduction.
It's reduction down to 30 meters?
Correct.
Okay, but that's regardless of elevation?
Correct.
Okay. So the only thing I got to go by is some of the pictures. I get what you're saying about the vegetation being disturbed. But from what I could tell from the pictures, they look like mature trees that were in growth. Typically in my lifetime, if a wetland is created by some other occurrence, mature trees die if they're underwater for any extended period of time. So I'm just trying to wrap my head around the concept that some of the vegetation exists. It may have been rooted and whatever, but it looked like it was
Yeah,
mature trees. So
Sure.
I'm trying to think why that would grow in a wetland.
exactly. So through you, Madam Chair, I'm going to ask that Tanner Lang come forward. He is a certified wetland evaluator and he is probably more qualified to speak to the case of vegetation in a wetland.
Thank you, Tanner. Come on forward. Thank you.
Do I have to state my name or do I have?
You're good.
That's
I'm good? Okay. Through you, Madam Chair. To the counselor that asked the question, mature trees can, or these are trees can occur in wetlands, but one type of wetland called swamp is dominated by trees, so that's what makes it a wetland. Seasonally flooded areas that are wetlands can have trees as well. In the Ontario Wetland Evaluation System, we not only look at trees, but we also look at different layers of vegetation as well. So shrub layer, tall, narrow leaf emergence, ground cover, all that vegetation community, we use that to define what is a wetland or not. So to answer your questions, some trees can occur in wetlands.
Are these the type of trees that would grow in a wetland?
Yes, in the Ontario, in the Ontario Wetland Evaluation System, in the appendices, it does list some of these trees that can occur in swamps, which is a type of wetland.
okay. Tracy.
Through the chair. So, right, there's specific species that do survive in wetlands.
Can you speak up a little bit? Sorry.
Sure. Specific trees do survive and thrive under those conditions. There's also an understory, is there not, when it comes to wetlands, that is very significant when it comes to determining that?
Through you, Madam Chair, to Councillor Richard. Yes, you're correct. There are other types of shrubs that are indicators of wetlands.
And the understory is prevalent or not prevalent?
It's gone.
It's gone. So we can't determine that moving forward.
Great. Okay, Harold.
Yes, thank you, and through you, Madam Chair, to the presenters. As you mentioned, a timeline to reestablish the type of plants would go. What sort of timeline would you roughly estimate that would take to reestablish?
Yeah, so through you, Madam Chair. Again, I'm going to defer to Tanner. I want to caveat that by saying that Tanner hasn't been on site. I do know, and nor have I. Mr. Rustenberg has been on site and indicated that there is quite a bit of wood chipping that was done on the property. So there's mulch that has been laid down. And my understanding is that depending on how much mulch was laid down, will determine how quickly it will take for vegetation to reestablish. But I'm going to let Tanner speak to that more specifically.
Through you, Madam Chair, to the councillor. I would just want to echo what Christy mentioned. There is a layer of mulch which may hinder the regrowth of existing plants there. Also in the report by Mr. Murdoch, consultant, there was movement of soil. So that movement of soil might have moved the seed bank away. So, and again, I haven't been to the site, so I can't give you a answer. But.
So
And just,
go ahead.
sorry, and just one last point there. Is there any lands or features on this property that would be classified as a bog or a fen?
Okay. Through you, Madam Chair, to Councillor. Based on my limited review of the property, But knowing that bogs and fens take thousands of years and they accumulate peat, I do not suspect that there is a bog or fen on the property. But to verify, I would need to go out.
Okay, thank you, Madam Chair.
I'm wondering at this time if Mr. Rustenberg can make some comments, if that's appropriate. You've been referred to a few times, Rusty, so you're the one who's been out to the property. Could we hear your report, please?
Yeah, thank you, Madam Chair. As it's been mentioned, our 2,500 square kilometer watershed, there's wetlands everywhere. So as far as my job, if I see activity in our mapping that's approved, any works going on in that area without permits, that's where I come in to try to negotiate with the landowner, like we do with permits. Like, what do you want to do with your property? You know, we'll try to work around, but keep it on side with the regulation. You know, and as to your comment, Councillor, areas do change. Like, I've got lots of cases on the go where it was massive area, but we go out, we ground truth it, and it's either smaller or it gets bigger. So the whole purpose of the mapping is talk to us, and that's kind of where we're at with this. And like I say, from the road to access property, you know, you need the owner's permission or search warrant, whatever. So from the road, I've got the mapping to work on. And, you know, Mr. Fairfield and Mr. Murdoch were cooperative. We talked about, you know, let's stop, pause the clock, and let's look at what we got going on and enter a remediation agreement. So that was, you know, on April 2nd that we're going to stop the clock. And then, like I say, the steps come into for the stop work order appeal. When I was on site, there's 3 samples, soil samples taken. And it's through Mr. Barrett's report, you know, the sampling he took. So I basically watched areas and noticed quite a substantial amount of shredded woody material all through the area. And some of the photographs, you can actually see it from the road. It looks like, you know, almost like flat land. So worked with the consultant for a bit, and he said, he verified, you know, there is wetland. So I said, okay, well, you can GPS it. We'll check it out with our staff, and hopefully that'll be part of the remediation agreement. Okay, the boundary's smaller or bigger, then we can move forward. Pardon me, Madam Chair.
What was that, Kriya?
Oh, sorry.
Did you have a question, Kriya?
No, nope.
Go ahead. Sorry, Russ.
No, so yeah, so basically, you know, looking at the property, there has been, you know, traditional or back bit of time of activity on the property. And like I said, it was just, you know, I'm doing, like, while I'm out there, it's just any works going in a wetland that aren't permitted. That's where I come into it. Let's stop the clock. We truly try to work with landowners through remediation agreement. What do you want to accomplish on your property? Okay, well, this is what the wetland boundary says. So, you know, or can you replace the wetland somewhere else? So that's all and from my view, the mapping, 8 out of 10 people don't know their property is regulated. So when I show up, it's like, what? And 2 out of 10 know, but 8 out of 10 may not. And so it's from that point on. And most of the remediation agreements we got, they're like, okay, this is what I wanted to accomplish. Yes, no, you can do that by the shoreline or whatever. So that's where, you know, my involvement. I'm not a wetland evaluator. I watched, you know, Mr. Barrett do his. I did witness and take pictures of, you know, the soil samples and vegetation that was there. But yeah, that's basically my involvement as far as issuing the stop work order. And like I said, it's under, you know, site alteration wetlands under 28. Just let's stop the clock and work together to try to figure something out.
Okay, Jerry?
Through the chair, in your brief little moments with this consultant out on the property, actually looking at the property, did you get the impression he was competent?
I can't really speak to that. I did ask him if he is a certified wetland evaluator. And he's not on the provincial listing, so. He seems very competent, he had the books, he had everything there, but to speak to his expertise, I can't.
All I have is a piece of paper.
Yeah, okay, sounds good.
Okay, any other questions? Peter?
I have a question through chair to staff. Is it a reasonable expectation that a landowner would know that he would need a permit for this kind of work?
So through you, Madam Chair, I think, speaking to what Rusty has already indicated, I mean, we encounter people with various levels of understanding with regards to whether or not their property is regulated. I do know that Mr. Murdoch has been, worked with the city at least with regards to some applications. I don't know if I can't speak to whether or not he knew that his property was regulated. What I can say is that had he gone to the website and looked at the mapping, he would have been able to determine that it was.
Thank you.
Yeah.
Tracy? No? Okay, Jerry?
Through the chair, to that point, prior, I think you mentioned 2012, 2014, the mapping was, is that initiated? Was there anything prior to that on the website?
So through you, Madam Chair, prior to 2014, was the mapping available on the website? Yes, it was.
It was regulated then?
I don't know if it was regulated then. I know that mapping was available on the website to the public.
Unregulated.
But for that piece of property, I only have mapping for the ministry. I only have the ministry's mapping from the latest 2014. So at least at 2014, for the last 12 years, it has been regulated.
So what's the map? The 2026 map? That's doing a tabletop kind of assessment?
It's the exact same as the 2014 mapping.
Okay.
The exercise for it. So the Ministry of Natural Resources provides us with that layer that says this is, in our best estimation, this is the boundary of the wetland.
Okay.
And then the Conservation Authority puts their buffer around it. So in 2026, we put that 30-meter buffer around that wetland layer and said, this is our regulated area. Anything that you want to do inside the pink area, come and talk to us first. And let's figure out whether or not you need a permit for it.
Great, thank you. Okay, Jerry?
Through the chair, so if I got it right, so they didn't really do any upgrade or verification between 2014 and 2026. Basically the same mapping, different buffer. Nobody actually went out physically anywhere and looked at all the different mapping to say, this is accurate or this is up to date.
Sure. So through you, Madam Chair, no, you're correct. Nobody had been out on site since 2014 to do a verification. We receive updated mapping from the province periodically, and on an annual basis, we update our regulated areas. We take those updated layers and put them into our updated mapping that comes forward to the board. In an in an unevaluated wetland, the ministry is not likely to undertake an evaluation unless the landowner requests it. So in the absence of a request, they're not going to go out and do that evaluation.
But even their old mapping in 2014, they wouldn't have looked at that with any kind of scrutiny to say it's changed. That buffer was the only real difference.
I can't speak to what their process is. Yeah.
Which is interesting, and why I asked the question previously about LiDAR. And they didn't have LiDAR in 2014. And I know our whole area has gone through the process of having LiDAR done. So that's another layer that would be in that mapping. So anyway, Kriya?
Thank you, and through you, Chair. I just wonder, is that LiDAR mapping, which we talk about so frequently, is it not available for us to research now in this situation? Or is it relevant?
I would say that it's not really relevant in determining the wetland at this point in time. The wetland layer is provided by the province. We would go the best way at this point in time, rather than replacing one desktop evaluation with a second desktop evaluation, the better option would be to go out and do an on-the-ground evaluation where we can actually verify what the boundary of the wetland is. Unfortunately, in this circumstance, we don't have the vegetation to put it through those 4 tests, and therefore we're requesting that the stop order stay in place until such time as we can do that. Likely in the fall, we'll be able to get out and take a look and determine whether or not we can establish that wetland boundary.
I fully respect what you're saying and everything that's been said to date. And I just want to clarify, the onus would be on the landowner to verify whether or not their land was regulated, correct?
Correct, correct. Yes.
Thank you. That's it.
Okay, Jerry?
Through the chair to Mark, I think you'd be the best to understand and reply to this. And it's irrelevant to what we're talking about today, but the idea, the concept, likely to affect in the future. That's a pretty great, like, how do you rationalize, how do you incorporate that into anything tangible? Like
I can tell.
that's a pretty big
It's
ask.
a development, right? And then you're in a wetland.
Through Madam Chair, I think what the province was envisioning, if I was to put myself in their shoes, was to provide flexibility in the decision making. Both of the officer as well as the situation that would be applicable for an activity that occurred. But certainly you can have minimal impacts, or you can have pretty big impacts depending on the types of activities that occur, and sometimes there's a bit of leapfrogging that occurs as well with different activity where, you know, it's small now, but maybe it becomes bigger in the future. So better to correct things when things are smaller versus bigger, bigger impacts. So those are all kind of big considerations I would say that the province put in the decision of people responsible for the decisions at play, like a stop work order or issuing permits or things of that nature. The permits and issuance of permits is similar.
Okay, Harold?
Yeah, so through you, Madam Chair, to Christie. So what are the ramifications of if we uphold this stop work order? I think I heard Mr. Murdoch say either today or the last meeting that he wishes to continue agricultural activity on this tract of land. If this stop work order is upheld, is he able to continue on the unregulated areas? Is there any areas that are obviously not wetlands he can continue on, or what is it, a blanket order, or how does it pertain, and how long, and what are his next steps to get to be able to use this land productively again?
Yeah, thank you. Through you, Madam Chair, it's a really great question. So the stop order is only applicable to lands that are regulated, right? So we can't stop people from doing work on property that isn't regulated. It's outside of our jurisdiction. The impacts to his farming, what we've asked for is that he stops removing vegetation, he stops, moving soil and everything else. Leave it sit and let us get a sense as to exactly what the wetland boundary is. I know he is actively farming sections of the property, and that's perfectly fine. But the areas that have been impacted, we ask him to stay out of those areas until we can reestablish whether there is a wetland on the property, which his own report says that there is, and what is the size of it, what is the location of it, what has been the damage to it, and how do we move forward in restoring its function. And so from a timeline for that, as I indicated previous, some of that's going to depend on what is the impact of the mulch that's been laid down, what is the impact of any soil that has been moved and any seed bank that has been moved out of that area. That would give our staff enough time. So Tanner would be able to go out as a certified wetland evaluator. He would be able to go out and verify the site specific and provide that updated layer that would then come back to the board and constitute the new regulated area on the property.
Okay, thank you so much. It's hard to just what percentage of this tract of land is farm, and how much of this land is actually in question.
Yeah, I'm gonna ask.
Is there any way we can get privy to that information through the applicant or yourself?
So I will defer to Mr. Rustenberg, who has been on site and had eyes on the property, to give an approximate estimation.
Yeah, as far as, like the regulated area, like, MF drain company machine was outside the regulated area. And I asked the excavator to move, to outside the regulated area. So it was kind of, was demonstrating that, stuff can be done outside the regulated area. And it was asking for that cooperation. As far as percentage, there's the one corner that Mr. Murdoch is actively getting some nice hay off of. And it's not in the regulated area. And, it's perfectly fine to work your area that's outside of our regulated area, unless it involves the city of Kawartha Lakes.
Or if there was areas on the property that he had been previously farming. So we sometimes have buffers to wetlands that are actively being farmed, and that is perfectly fine. Yeah,
That's what I
that's,
was-
yeah,
To establish how
But-
big a percentage of the land that would entail.
I haven't measured it, or I can't speak to.
Mr.
exact
Murdoch
distance.
might be better.
Mr. Murdoch knows.
So, yeah, Mr. Murdoch wants to speak, so we'll go ahead, Andy.
There's 10.6 acres from the gentleman that custom does my hay on the east side of the property. Along the highway portion of the property, that's unregulated, there's probably another 9 acres that I keep the grass cut. And I try to keep the grass cut only because otherwise I have a weed inspector after me and the whole thing. So balance of the land, as identified by my consultant, that he's suggesting that this wetland is somewhere between 1 and 2 hectares out of the entire 60 acres. This is where I'm a little frustrated. There is wet holes, I acknowledge that, but there, as Christie pointed out, there's 5 aspects of creating a wetland. There is no standing water. We just had 3 inches of water down recently. I was over there this morning, and there is a couple of puddles and trenches where the machinery was. There is a couple of wet spots. I mean, not any bigger than that chair next to the topsoil pile that I pushed up in 2012. Prior to 2012, there is no regulation on it. And my frustration is that I moved the dirt. So I created the wetland. I want to put the dirt back. There was a reason why the dirt was moved in 2012. And that was rescinded by the city in 2014. So I'm at a stage in my life where I don't need any more aggravation. I just want to plan my farm, have fun, grow food, and maybe build a little house over there one day if I sell my factory, which is across the road from it. So that if we were to come to a consensus on this, the maximum area is under, it's maybe 3 acres. Let's put it that way. There's maybe 3 acres out of roughly 40 that could be considered wetland. The frustration is that that didn't exist at all prior to 2014, which I only when somebody asked, well, how do you verify it? Well, if he wants, lawyer wants to go and check the deed of 2005 or 2006, I forget. But that's how long I've owned. And there was no regulations whatsoever at that point in time when I bought it as farmland. And this is a very frustrating thing, that there is such a thing as the right to farm. There is such a thing as the right to work on your own land at your own pace. There was no regulations of moving dirt then. There are no regulations of moving dirt today. And the lawyer knows that. And as well, there's no bylaws in the city of Kawartha Lake about brushing or cutting trees.
Not
So
yet.
we can go, we're going from one side of the fence to the other. You want to prove that it's wetland. I want to prove that it's unevaluated or undeveloped farmland. There's a, and the Conservation Authority's got a job to do to protect our environment. I got a job to do to produce food. And somewhere in the middle, there's going to be a consensus. But as far as the stop work order goes, the work order was placed because of the brushing. I didn't know it was regulated land, like, I'm not going on my damn computer every day to check, see what my land is, I know what it was when I bought it. And until such time as the ministry puts themselves together and puts something concrete, because everything that's been discussed here today, including what the lawyer had to say, is discretionary on which side of the fence you're on.
Okay, so I'm trying to move this forward a little bit. Go ahead. Yeah, through you, Jerry, go ahead. Yeah.
I'm just gonna ask, if you went ahead with the stop work order, and Tanner, you'd be best to speak to this maybe. What is your timeline, and then what's he set up against? Like, how many years do you want to see vegetation if it ever appears? How many times during the next forwarding years is this get looked at again? Like, I just wonder what the rough idea is on that. From his perspective, trying to work forward if you go ahead with this.
Yeah, so through you, Madam Chair, I'll let Tanner speak to sort of what the timeline would be, but once the wetland boundary has been identified and the restoration plan has been identified and implemented, then it becomes a new, then we would adjust our wetland regulation on that property. And we wouldn't go back and reevaluate it unless there was more work that was taking place inside the regulated area without a permit.
Or referencing your fourth point that you need to see vegetation,
Right.
how
And
long
so-
does he need to have to see what he's expecting to see? And at what point in the future do you say, no, it wasn't?
Tips over it, how can you tell?
If that makes sense to you, Tanner. Yeah.
So, I'm gonna ask that question.
Through you, Madam Chair, to the Councillor, the question. In terms of timeline, generally when we're evaluating wetlands, we do multiple field visits just because wetlands are dynamic. For example, in early spring, nothing's growing. In the summer, so during the springtime, that's usually when we see the most flooding. So we would go out ideally in the spring, and then we'd go back in the summer to use those vegetation communities to infer where the wetland boundaries are. So that's at least 2 field visits. Now, that's when we're talking about a wetland that hasn't been impacted. With this case, with impacted areas, I can't say for sure, but at least twice. One in the spring, one in the summer to verify.
So just on that impacted area, and Rusty was the only staff member who was there. You said something about wood chips?
Yeah, there's, Madam Chair, there's wood chips in some of the areas. It's all treaded mulch. It's basically mulch. So, if that mulch gets removed, then, the seed bank is going to have a better opportunity to do what it's supposed to do. A lot of times when that land's destroyed, we give it, they put up sediment fencing and then let the natural vegetation take over. But in some cases where it's an extensive change or alteration, then it's going to take a little more time. But move the mulch out of the way, and maybe the seed bank will come up quicker.
Okay, and Andy?
Jared, I can remove the mulch very quickly by disking the land. And land is dry enough that I could disc the whole place, other than a couple of holes. You want to, I can mulch it in, I can disc it into the ground tomorrow.
Yeah. Okay, thank you for that. Okay, so we've kind of gone all over here. So we can, so Andy, do you want to do your, like a formal presentation at this point?
Well, I can't, I'll make it really brief because I've gone over some of it
Yes.
already
Come on up,
because
Andy.
of the questions that.
Come on up here so we can hear you. See you.
Generally speaking, I've never had a problem being heard. I alluded to the fact that, the property has been a farmland since 1823, a couple hundred years. There's never been any flooding on that land that affected anybody anywhere. The amount of soil that they're talking about that was moved is maybe the odd, when you pulled the tree out by the root, is there's maybe some area there. The vegetation on the property was elm. There was a fair bit of it, great firewood, great lumber, not elm, ash, because ash borer went through. I know I took 50 trees off the south side of the road because they were a hazard. The hazard was the trees. There is no hazard to anybody else other than if they're on my property. Because the trees, there was a lot of those trees dead. We did have a storm go through and wipe out a couple hundred small poplars on the west side. There's just a path that leveled things. That had to be cleaned up. There's piles there to be cleaned up. The whole aspect of this property being wetland is really a problem with me, because I am a farmer. I've been farming since 1970, not in Emily Township. I've been farming in Emily Township since '89. But you don't go and farm a wetland. Nobody's that stupid, I don't think, to farm a wetland, because you're not going to get a crop. So that's the logic. I operate on logic and results. There's never been any flooding occur on that property. It has a fall on elevation. I've got an elevation map there from 2012, shows the top elevation where there's assumed to be a bit of a wetland, is the elevation is 253. The river is 244. And this is in meters. And the bottom end of the land and the lowest spot on the land is 249.6, I believe. So there's a gentle fall from east to west, and then the water runs north into the river underneath the culvert. I don't know. I'm open to questions. Like, I don't know what more to say to you other than I have difficulty spending money to prove something that I shouldn't have to prove in the first place. Like, there was no wetland mapping or anything else on that property when I bought it. And there hasn't been up until 2014. And logic says that I created it because I moved the topsoil. And by putting the topsoil back to where it belongs, there will be no wetland.
So I'm just thinking, well, when you bought it, maybe they didn't have proper mapping back then.
Or maybe it was just
you know,
farmed.
Yeah, I'm not sure.
Yeah.
So
Like
that's
proven. Yeah,
yeah.
That's something that can't be proven
Mhm.
one way or the other. I can ask the neighbors, was that land farmed before I bought it? Yep. I know there's
Talking
cattle.
about wetlands, I'm not talking about farming, yeah.
Right.
Yeah. Okay, are there, yeah, Tracy?
Thank you, through you, Chair. So how, prior to this, how much acreage was being farmed on this parcel prior?
90% of the property was being farmed.
What kind of crop were you?
Hay and there's not been a grain crop on it for probably 40 years. Now that's my intention because the land is there to do it. Vegetation wise, it's my intention. And again, these trees don't grow in swamps. It's my intention to have it cleared and have sugar maples all the way on 3 sides of it. Because that becomes a crop for somebody else in the future.
So you're approximately 60 acres now.
That's correct.
What is the actual acreage if you were to
Farm it?
farm it?
I've estimated somewhere between 55, 56 acres. So there'd be about 4 acres that I would retain as marginal land.
Yeah. Oh, Priya, sorry. Priya, you have a question? We can't hear you. Sorry.
Yeah.
She's gone?
No,
She's there, she just took her hand down.
Oh, okay, great, okay. So to be clear, you just want to farm this,
That's correct.
yeah, so historically, so, okay, that's great, so, any other questions of, Mr. Murdoch? Well, thank you for coming and,
Just before Mr. Murdoch leaves,
Oh, yeah,
I actually
sorry,
have a few
Harold.
questions, if I
just
might.
a sec, Harold has a question first, sorry.
So, yeah, so, excuse me, through you, Madam Chair, Mr. Murdoch. In your opinion, so if this stop work order was sustained, it was carried on, ask questions, but how would it impede your upon?
Okay.
Well, considerably, if it stays, because,
How so? Explain to me.
well, if I understand it, you're asking me what it'll affect?
Christie has said that you can maintain the work you're doing on.
Well, it would limit me to about less than 15 acres right now, 15, 16
You
acres.
said you were working 56 of them.
No, I said I could work 56 of it. I could work 56 of it.
Okay, so the balance between the 15 and the 56 is this acre that needs to be brushed off.
Yes.
Okay, so that's the impediment. Okay, so this land is farmable land, but it is currently being farmed. It needs improvements before it can be seeded.
That's correct.
Okay, and that area is about 45 acres.
Yeah.
Roughly
40.
40 acres, let's say. Okay, no, that's what I was looking at. So this is the 40 acres you want to get into production as soon as possible.
That is correct.
Okay, thank you.
Okay, so at this point, staff and our council can ask questions also. So. Okay, Mr. Jewell?
Yes,
Jim?
thank you. Mr. Murdoch, can you hear me?
Yes, again, thank you.
Okay, thank you. So you mentioned that in 2012, you pushed up some topsoil.
That is correct.
And from the period of 2012 to 2026, did you ever take any pictures of your property?
Yes, I did.
area? All right. And you haven't produced any of those pictures to us today, have you?
Christie saw them briefly a little while ago, like a week or so. When was it? We were in 2 weeks ago.
But no, they have not been submitted.
All right, so the board doesn't have the benefit of any pictures of the property. So for example, in 2014, did you take any pictures?
No, I took them yeah, I did take them in 2014. I
But
took pictures then.
we haven't seen those pictures.
Christie has.
All right, well, you
But I
haven't
can have them for you. I just haven't got them with me. Somebody else has got them right now.
All right, well, it might be helpful for the board to be able to see pictures of the property that were taken prior to the work being done. So that's my point. Let me fast forward to March of 2026. You hired a contractor by the name of Brian Fairfield.
Yeah, M&F drainage.
Right, M&F Drainage. That's what they work, that's the name of the company?
That's their name, yes.
Right. And I take it from the name that one of the things that they do is drain.
That is correct. They drain they put tile drainage in my farm a few
Right.
years back.
Now, you haven't called Mr. Fairfield as a witness?
No, I didn't realize that would be necessary, sir.
Okay. And you haven't produced a contract? Did you have a contract with Mr. Fairfield?
In this part of the world, we deal with a handshake.
All right. So what was the price of the contract, sir?
The price of the contract was 40,000+ for brushing and another 50-some thousand for the tile.
And you're telling us that for approximately $90,000, you didn't have any, I want to be careful here, sir. Are you telling us that you spent $90,000 and there's not one piece of paper that speaks to that?
I haven't spent the money on tiling
That's not
because
my
of the
question,
stop work
sir.
order.
Not my question. My question is, you spent $90,000 on Mr. Fairfield. Is it your evidence that you have not put that in writing in any way? He hasn't given you an invoice. You've just
He gave me, I can show you an invoice for the work
Okay,
that's
you
been
haven't
done.
you haven't produced that, have you, sir?
Why would I produce that invoice?
Well, it might be helpful, sir, so we know the nature of the work that was being done. We don't know what it is that you've done here because you haven't produced any evidence of a contract of the work that you now tell us you spent almost $100,000 on.
Excuse me, but I haven't spent 100,000 yet. I committed to basically that. I have spent 40 plus on doing the brush work. Again, a lot of the times when you know somebody, you don't need to have your I's dotted and your T's crossed because you trust people. And I trust the people that I deal with, and I have over the years.
All right,
Because we don't get involved with lawsuits.
let's have a look. If I could ask Melanie to put up a picture from the hearing brief. If I could ask that we look at the last tab, which shows the drainage machine.
Excuse me, but it's not a drainage machine.
Well, that's what I want to ask you about, sir. So let's look at this picture.
Yep.
We could go to the last tab of, it's not in that hearing brief, it's in the, it's in the book, it's in the hearing documents. It's the last tab, pictures of the drainage. Sorry, it's exhibit 7J, exhibit 9, drainage tile machine photos.
It's just gonna take her a minute to grab it. Ken, just give us a
Okay.
second.
Thanks.
What do you do with this? Did grant. You could put drainage tile. That's was it. Well, I seen drainage. And we talked about you, but they go drainage.
That the one?
Yes, that's it.
There's a better picture with the name on the side.
I can't, I just see an agenda item. I don't see the picture itself.
Pictures there, we saw.
Okay.
On the side.
All right, for some reason I can't see it, but are you able to see, sir, that it says right on the machine,
The company name.
says drainage on it. So we have this picture of the machine. Could we just scroll down a little bit?
It's a company's name. If you
Okay.
look at the machine,
Yeah, it says
Yeah.
Drainage Inc.
I agree. That's the name of the company.
All right.
Most companies have to have their name on their equipment,
Sure.
whether it's a bulldozer, an excavator, a tractor,
And you
whatever.
have not produced the contract with this company for us to look at and see what it is they were up to.
Well, I guess there's an element of trust that's lacking in this whole thing.
All right, let me ask you this, sir. When you dealt with, we can put that picture down. When you dealt with Mr. Fairfield, he's a contractor, right?
That is correct.
And did he tell you that did you have any discussions with him about the regulated area in this area? Did he discuss with you the regulated area?
No,
Okay, he didn't discuss that with you. All right. All right.
Madam Chair.
Yeah, yeah.
Madam
So-
Chair. Yeah, my error was assuming it was a drainage machine, but that was from our meeting. They were discussing which way the drainage tiles were going, so I just thought it was a drainage company. Eventually, they wanted to put the drains in, so.
Okay, I just have one last question, and that is, when the work was being done in March, no one took pictures of the work as it was being done.
No, sir.
All right. So we don't have any pictures or evidence of what the extent to which trees and other vegetation was removed, because no pictures you nor your contractor took no pictures of the destructive work that you were doing.
The clearing work we were doing.
The clearing work that you were doing, no one took any pictures.
No, we didn't feel that it was necessary. We're working on our own property.
Right, and no one took any measurements.
Again, there's an element of trust, sir.
Well, there's an element of trust between you and your contractor, but I'm talking about an element of trust between you and the public interest in regulating wetlands, sir.
Well, the public interest you're protecting, I assume. But I have stated, and if you want me to go under oath to do it, I'll do it. That, as I said, there has never in 200 years been a problem with drainage on that property. It doesn't meet any of the criteria. It might be a bit of soil, but that happens no matter where you farm or where you are. But it does not meet the criteria to consider it a wetland.
All right, here's my last question, sir. You have not filed any reports or any evidence about the state of this wetland before you did the clearing work.
Well, I didn't know it was a wetland.
That's fine.
And it still
Just, sir,
isn't.
answer my question.
Certainly.
My question's simple question, sir. Before you did the clearing work, you have never asked a consultant to assess whether or not there was a wetland there.
I didn't do it when I did my farm a few years ago. I didn't do it when I've been with other farmers that I was banking, because we didn't need permits. We didn't need all this nonsense. And we were still protecting the environment.
So that's your answer, that you don't have a consultant's report because you think it's all nonsense.
Well, you've told me that my consultant is useless. And so consequently, why would I get another one? Because the likelihood he's going to be useless is in your terms.
All right, I think that those are all my questions. Thank you.
Okay.
Good.
Yeah. Okay, so do staff have any questions of Mr. Murdoch? No, okay. So, all right.
Could I have a question? If I
Yeah.
could, not for Mr. Murdoch, but the conservation officer. I'm sure I was right to get your name, but you're the one that initially went to the property.
Yes, sir.
Okay. And you assumed that drainage was taking place because you saw the equipment.
No, sir, yeah, when I initially saw the drainage, I saw, that's normal practice that's been going on, drainage tile being put in farmlands. Then we had an April 2nd meeting, and they were discussing which way they were laying the drainage tiles on the property. So that was my concern, is why are you getting drainage tiles if it isn't a wetland? And, and like I say, the machine, that's my error. I just seen, and, the talk April 2nd about putting drainage tile.
Had you known that that wasn't a drainage machine, would you still proceed?
Well, cutting and working in the unauthorized works in a regulated area would be, stripping land, moving land.
Sure. Okay, and then I've heard earlier that there are 4 criteria to qualify wetland, and we have proof of 3 of those criteria. We don't have proof of the 4th because the vegetation has been removed.
Well, yeah, that was the purpose of the stop work order. Let's take a look at what's there.
Sure.
Let's not wreck any more stuff till we figure out what's there. That was the purpose of the stop work order, to work with Mr. Murdoch to figure out the wetland boundary and the next steps. So that was the purpose of the stop.
But the fact of the matter, okay, and I appreciate that. The fact of the matter is, though, we really only have 3 or 4 criteria that we can be sure of.
Well, we couldn't assess the property. That's the problem.
You have to have 4.
Pardon me?
But under the regulation, you have to have 4
Yeah.
We can prove 3, we can't prove 4.
We can't even prove, because we don't have access to the,
Regardless of the reason, we can't prove 4.
I'm not sure how you prove it if you can't go there and look at it.
And I'm not debating that. That's just my question is, we can prove 3, we can't prove 4.
Not today.
Christie, do you want to speak to that at all, or?
Yeah, through you, Madam Chair, you're correct. We cannot, into the state of the way that the property is today, we cannot, we can't get the information that we need in order to prove for.
But you could in the fall, is what you said.
Potentially, yes.
Yes,
Yeah.
okay.
Once vegetation has the chance to reestablish itself.
Yeah,
Yeah.
okay. All right, Andy?
Madam Chair, they can't prove any of them. Because first of all, there's no standing water, and that's the one that's most prevalent. 2, the vegetation is only one that hasn't really been disturbed. The brushing has been done, trees have been down. And the other 2, when it comes to the soil, there's the 4 criteria that have to be met. And then there's a 5th codicil on there, that if the land is being farmed, regardless, it's not wetland.
You can, I think you can still farm in wetlands, so.
Yeah.
Yeah, so.
As far as
Yeah.
the
So that's not
Back to-
necessarily true.
Mr. Doble's point, they haven't proved any of the 4 at this point.
Yeah. Okay, Jerry.
Through the chair, just to clear up one thing that somebody seems to be confused about. There's lots of working farmland that's been irrigated and worked for hundreds of years that they couldn't afford a tile drain. And now they do tile drain it because it improves the production. It's got nothing to do about it being a wetland.
Mhm.
You tile drain farmland, it improves production.
Yeah, okay, great. Okay, so thank you. We're gonna make a motion that we're going to go into closed to deliberate. So can I have a motion to move into close, please? Yeah, I think, yeah, we take a 5-minute break. Yeah,
Meeting is like.
I think we're gonna put it off. I'm sorry, but I don't know. I mean, Tracy has to leave, Kriya has to leave, you have to leave, right? So
Anyway.
we won't have a quorum.
Let's adjourn to August.
Pardon?
Let's adjourn to see August.
No, we're going to.
Have an August meeting.
The chair.
Yes, we're gonna have to have an August meeting.
Yep.
Yep.
Yeah, so we're gonna take a 5-minute break and then we're gonna go and make a.
Can I ask a question? Could I ask a question?
Yes,
When we go into closed, will it be on this same link?
Yes.
yes.
Okay, so I'm gonna stay here. Thank you.
We're gonna go into close. Jerry, gonna move that. Peter seconded, all in favor, carried.